After you've drafted your estate planning documents, often people are like, what do I do with it now? Well, my recommendation is that you put it in a safe place, but not necessarily a place that nobody can access it. So I don't love them to go into safe deposit boxes unless you have somebody else acting as a signer. If we find that it's in a safe deposit box and nobody is a signer, it may take a bit of time to access these estate planning documents. We need to tell the bank that we believe the estate planning documents are in there. It might even require you to pay an attorney to write a letter indicating that you believe the estate planning documents are in there. The bank will then open it up while standing behind you, not letting you take anything out. When we see that there in fact is the estate planning documents, additional steps are required in order to access those estate planning documents. So let's not put it in a safe deposit box unless somebody is a signer. Same with a safe. If we put it in a safe, make sure somebody has the key, the code, access to that safe. Now, most attorneys no longer put information in the estate planning documents, such as social security numbers. So, really, there's not a huge risk of information getting out there if somebody were to break into your house and find these estate planning documents. However, sometimes people don't necessarily want their kids or family to find the documents and peruse through them, which I also understand. So keeping it somewhere like an office in your house or somewhere in your bedroom, somewhere where people do not have immediate access. So maybe not the coffee table. It's important that you let people know that you have these documents in place. In Oregon, there's really no central bank of estate planning documents. So each attorney who drafts it does keep a copy. Some of us keep originals, most don't. All of us usually have to keep though copies. So if you know who the lawyer is or leave a card for your kids of who the lawyer is, then the children should have easy access. If this is something you've done online, nobody else might have seen it. Nobody else may have a copy. So it becomes really hard for kids to locate the version that is signed and properly executed, which does create delays and make it so that your will actually is not valid. So working with an attorney who has a copy is a nice way to ensure that somebody at least maintains a copy of your estate planning documents. So if you do not want to send it off to friends and family, which I usually recommend, sometimes people really want to send copies out to their kids, but I personally don't love 15 copies of your estate planning documents everywhere out there. So I don't encourage you to leave them at the bank. I don't encourage you to send them to your kids. However, letting your kids know that you do have these documents in place. If you've used an attorney, give them that attorney's card. It's really none of their business who you've left your assets to when you pass away. But it is really important, especially in the event of incapacity, let your kids or friends or family or whoever you put in charge of helping you during a period of incapacity or administering your estate after you pass away. It is important that they, in fact, know these documents exist and perhaps where they can locate them, even if it's referring them back to the attorney. If they're calling the attorney, we will likely need proof that you have passed away or have become incapacitated before we can send those documents off unless you've given us prior permission. So there's a little bit more steps, but it's not like trying to access it in the safe deposit box. If you have sent it off to friends and family and want to change any distribution or who's in charge, it's important to pull all those documents back from each person and let them know that you're making changes so there's not an issue down the road of which document controls. Usually it's the last document that you executed. However, anytime we have multiple versions with multiple people, it creates a potential area of litigation, which I personally love to avoid. So go ahead and maybe not send out those documents to everybody. If you do want a family meeting, that is fantastic. Sit down with everybody, let people know who's in charge, let people know, kind of some basics, but not necessarily give them the full version unless you really, really want to. Now, after your passing, your whoever's in charge will need to find these documents. So again, just find a way for them to easily locate them. If you have questions about where to store stuff or, you know, how many versions or how many copies you should send out there, feel free to contact a local attorney in your area. I think it's best if an attorney drafts these documents, if nothing else, so that there is a copy that is easily accessible after you pass away, but also primarily so you are ensured that what your wishes were are carried forward because they will be properly drafted.